The Supreme Court of Ohio upheld the imposition of the Ohio Commercial Activity Tax, or CAT, on $108 million worth of merchandise shipped to DSW's Columbus Distribution Center before items were sent to stores both in and out of Ohio. In a 5-2 decision, the Supreme Court rejected a more than $850,000 refund request from Jones Apparel Group, which makes Nine West shoes, for merchandise shipped to DSW during tax years 2010 through 2016. The refund request had been rejected by the Ohio Tax Commissioner, and the Ohio Board of Tax Appeals upheld that decision in 2023, finding that Jones Apparel failed to prove it was entitled to a refund. Writing for the court majority, Justice Jennifer Bruner stated that Jones Apparel witnesses provided estimates to the BTA, insisting that at least 80% of its goods sent to DSW were not subject to the Ohio CAT. Simply testifying that one is confident that at least 80% of the goods ended up outside of Ohio falls well short of the evidentiary showing necessary to prove the amount of the claimed refund, she stated.
What would you want us to say as a matter of law to guide the tax commissioner for the future?
I think you've got to say you can't stop at the initial shipping location. You've got to look at where the goods are ultimately received. And a taxpayer, we acknowledge, does have a burden of proof of showing where those goods are ending up. In this instance, we have demonstrated that ultimate store location is a fair proxy.
As part of the sales, the parties said, hey, put on the shipping labels. These are going to go to Ohio, the distribution center. But then right after that, or sometime thereafter, these pallets are going to be shipped then to Michigan, or they're going to be shipped to Indiana.
Kind of like what they put on your suitcase if you've got a...
Exactly. So that's how you would know that, hey, well, this is going to start in Ohio, or it's going to be on the first leg, but it's also going to go on the second leg.
In a dissenting opinion, Chief Justice Sharon L. Kennedy wrote that under Ohio tax law, the vast majority of Jones Apparel's goods were ultimately received outside of DSW's Ohio stores and were not subject to the CAT. She added that Jones Apparel's expert witnesses presented evidence indicating that far more than 80% of its goods were not subject to the tax and would have held that the company proved it was entitled to a refund. Because Jones Apparel did not provide adequate evidence, the court affirmed the BTA's decision.